12 results are out for CBSE, and now moving ahead to the Sabarimala case. The Supreme Court is continuing the hearing in the case reference involving women's entry, Dawoodi Bohra excommunication, and Parsi women's rights issues. Solicitor General Tushar Mehta said courts should first examine whether a religious practice violates public order, health or morality before applying Article 25 protections. Mehta argued that Articles 25 and 26 must be read together and cannot be treated as separate or isolated constitutional rights. The Solicitor General said the absence of the word sex in Article 25 does not mean gender discrimination is permitted under religious practices. Let's go across to my colleague Sambhav Sharma to get some more updates on the arguments taking place in the court. Sambhav.
The 9-judge Constitution Bench is hearing the Sabarimala reference case, and it is day 15 in the Supreme Court when the 9-judge bench is hearing, and involving certain questions like women's entry into Sabarimala case and also the FGM, Dawoodi Bohra excommunication case, Parsi women's rights case, among others. So these are the important topics, important matters being heard in the Supreme Court under the Sabarimala reference case. And here important arguments made by Solicitor General Tushar Mehta, and he said that courts should first examine whether religious practices violate three important aspects, which is public order, health or morality, before applying Article 25 of Indian Constitution and protection under that. Also, as we argued that Article 25 and 26 must be read together, it cannot be treated as separate or isolated constitutional rights. And also, Solicitor General has said that the absence of a word sex in Article 25 does not mean that gender discrimination is permitted under the religious practices. And now, certain remarks made by judges also, where Justice Nagaratna, only woman judge in the 9-judge Constitution Bench, as Justice Nagaratna said, interpreting Article 25 Clause 1, Article 17 of Indian Constitution. She said that you cannot say rights under Article 25 Clause 1 is subject to Article 17. It can bring in as social reform, but it's different from saying that Article 25 Clause 1 is subject to other articles like Article 14, Article 15, Article 17 of Indian Constitution, which deals with untouchability, and she further said that it is subject to Article 26 to 28 of Indian Constitution because it uses religion, as she was referring to, as said by Senior Advocate Gopal Shankar Narayan. On the other hand, Justice Jaimala Bakshi, another judge in the 9-judge bench, said that court must ensure that majoritarian beliefs do not override the constitutional principle. And he also noted that Article 25 of Indian Constitution, because the whole discussion is around Article 25 and Article 26 of Indian Constitution. And if we talk about Article 25 is freedom of conscience and free profession, and Article 26 of Indian Constitution, which says the freedom to manage religious affairs. The whole discussion in the top court is going around these two particular articles of Indian Constitution, which comes under Part 3 of the fundamental rights. So they are very important. And here Justice Jaimala Bakshi has said that court must, has noted that court Article 25 guarantees equal religious rights to all persons, regardless of the number or size of the community.
Right. And let's put that on our screens as well, Sambhav, what the arguments or the observations rather of the judges have been. Justice Nagaratna has said that you cannot say rights under Article 25(1) is subject to Article 17. It can be brought in as a social reform, but it's different from saying Article 25(1) is subject to Articles 14, 15, 17, etc. It is subject to Article 26 to 28 because it uses religion, as said by Gopal Shankarayan. In fact, Justice Jaimala Bakshi also said that courts must ensure that majoritarian beliefs do not override constitutional principles. Justice Bakshi also noted that Article 25 guarantees equal religious rights to all persons regardless of numbers or size of a community. On this, Solicitor General Mehta argued that Ayyappans can qualify as a separate religious denomination or at least a section within a denomination. The Solicitor General defended social reform laws against practices like witchcraft and animal sacrifice, saying constitutional reforms have been accepted by the society over a time. In fact, moving ahead, Supreme Court bench has observed that Hinduism is a way of life. Visiting a temple is not mandatory to prove one's faith. To remain a Hindu, it is not mandatory for a Hindu to visit a temple or perform any religious rituals. Even lighting a lamp at home is sufficient to demonstrate one's faith. Supreme Court has made that observation. The 9-judge Constitution bench headed by Chief Justice of India, Suryakant, made these observations. Sambhav, help us understand how the Solicitor General was able to prove his case. In the case, the Supreme Court has given a general observation on the matter. So far, Hinduism doesn't need any ritual to be performed.
Well, absolutely. Here, as we speak, day 15 hearing is going on in the Supreme Court in the Sabarimala reference case, and Solicitor General Tushar Mehta making submissions in the Supreme Court before 9-judge bench, and the post-lunch hearing is resumed in the Supreme Court. And as you rightly pointed out, there are certain important observations made by different judges. Although they are hearing the case, there are, it's a kind of discussion between judges on one hand and many senior advocates who are appearing, and there are certain arguments being made in the Supreme Court, and as you rightly pointed out, a few of them are made by Solicitor General Tushar Mehta, where Article 25 and Article 26 being interpreted widely by different senior advocates, and Solicitor General has, in a way, defended certain social reform laws against practices, and also has argued, there are certain denominations within the religion, as Solicitor General has argued that Ayyappans can qualify as separate religious denomination or at least a section within a denomination. And also, if we talk about further arguments made by Solicitor General, he said that absence of word sex in Article 25 does not mean gender discrimination is permitted under religious practices. But Justice Nagaratna has made a certain observations and said that you cannot take rights under Article 25 Clause 1. Now, Article 25 Clause 1, if we talk about, it says that subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to the freedom of conscience and right to freely profess, practice and propagate religion. This is Article 25 Clause 1 of Indian Constitution. And Justice Nagaratna said you cannot say that under Article 25 Clause 1 is subject to Article 17 of Indian Constitution, which deals with untouchability. She further said that it can bring in as a social reform, but it's different from saying that Article 25 Clause 1 is subject to other articles like Article 14, which is equality before law, Article 15 of Indian Constitution, Article 17, among others. And she further said that it is subject to Article 26 to 28. And other judges also made certain, certain remarks. And as Justice Jamal Bakshi said, the court must ensure that majoritarian beliefs do not override the constitutional principles.
All right. Sambhav, thank you very much for bringing us all those latest developments on the Sabarimala case hearing. And now moving on.